Well, good afternoon, and good afternoon to people who are tuning in via Facebook. Um, April 20th is going to mark my 1 year since I was appointed and sworn in as county attorney. So I'd like to provide a little bit of an update on the status of some of the things that have happened in our office in that past year. And this is by no means the only things that have happened. Addressing a backlog of cases that was waiting to be charged when I took over was one of my top priorities. But I knew that in order to address that issue effectively, I had to take steps to fulfill the vacancies in the various positions that we had at every level in this office. The day that I became county attorney, I was briefed that we had a vacancy rate of 20%, and that was not only across the board, but that was pretty much true for every single position that we had. And I was also told that we would have another 20% of the population of our employees that would be eligible for retirement by the end of the year. So we were facing a 40% vacancy rate. Due to some extraordinary efforts on the part of the employees of my office, the overall vacancy rate is now less than 10%. In fact, when I include offers that are out to prosecutors and those that are in background checks, our prosecutor vacancy rate is in the single digits. So this is a remarkable effort by our communications, human resources, background staff, and hiring managers. They have worked hard, and their hard work has paid off, and it has brought our office up to numbers where we can do what we are supposed to do, which is to make this community safe. However, even with a staffing deficit, I prioritized our charging backlog office-wide, and particularly in our Vehicular Crimes Bureau. I did so because cases in that bureau directly impact public safety when impaired drivers are not held accountable. A few months after I took office, we addressed a majority of the aggravated DUI backlog. And in fact, as I've reported in the past, we had 800 cases that had been filed but not put into the court system. That was because of staffing shortages on both ends, and the clerk of the Superior Court, Jeff Fine, allocated resources and cooperated with our office, and I'm grateful to him because we were able to eliminate 800 cases, so that backlog is down to 0. As far as the general backlog of charging cases, when I took over, there were over 10,000 left to charge. In 1 year, we have reduced that to under 6,000 cases. So this is a tremendous accomplishment for the office, and it's due to the hard work of our employees. This office is always going to have cases that are waiting to be charged, but it is my goal that all cases will be reviewed and a decision made within 90 days of submittal. We are working toward that goal. Whether charging or trying a case, it is my responsibility to ensure people are held accountable, and that accountability includes their sentences are appropriately carried out. That is why our office has been taking steps to ensure Aaron Gunch's lawfully imposed sentence is carried out. As most of you know, my office has filed several legal challenges to protect the rights of the victims in that case and to ensure that everyone performs their legal obligations. Victims under Arizona's Constitution have a constitutional right to a prompt and final conclusion. I cannot ignore victims' constitutional rights, and decades of delay in capital cases undermines theirs and the public's confidence in the criminal justice system. In our democracy, we who are elected serve at the will of the people, and elected officials have the responsibility to ensure that the laws created by the elected legislative body are followed. In the executive branch, which our office is a part of, we do not make the law. We ensure laws are enforced, and that applies whether you are the county attorney, the sheriff, or even the governor. We are not free to ignore laws, even if we don't like them. Every elected official must take the necessary steps, whether it be identifying resources, as we've done, or refocusing priorities, as we also have done, to address and carry out the duties of their office. Government has limited resources, even in the best of times, and as leaders and stewards of the public's resources, we must find a way to get our jobs done. And with that, I'll take questions. Graham?
Hi, good afternoon.
Good afternoon.
Congratulations on 1 year.
Thank you.
Let's talk about Gunches. How significant is this case? Why should this matter to the average person?
This case involves an individual who in 2002 was taken out into the desert and executed. He was a member of our community. His family is a member of our community. And the law called for the death penalty. He went to trial. He was sentenced to death. He's exhausted his appeals, both federally and in the state. And it's vital that the rule of law be upheld. I mean, that is the underpinning of our system of governance. That's why it's important.
The Supreme Court has said that the governor does not have to carry out the order based on the execution warrant. So what are the grounds you're using to fight this?
So the Supreme Court's ruling was limited, as you pointed out, to the execution warrant, but it did not say, in fact, it recognized that the governor does have a duty to follow the laws and that she's taken an oath to uphold the laws. And the laws do not allow her to unilaterally make the decision that somebody does not get executed when they were sentenced without going through the Executive Clemency Board and getting a recommendation from them. That hasn't happened. And in fact, Mr. Gunches, as you know, waived his executive clemency hearing. So under the law, as it now stands, he is to be executed.
In terms of the precedent this would set, a governor saying, no, I will not carry out that execution, how significant is that?
It is significant that someone would say, I'm not going to follow the law. There are other states where governors have said similar things, but their state law allows for that. Arizona's law does not allow for that. Arizona's law requires that all of these matters, reprieves, pardons, etc., commutations, go through the Executive Clemency Board. That has to happen.
So what are the options for the judge tomorrow?
Well, we have two things going at one point. Number one, the execution warrant that was issued for 35 days. We've asked the Supreme Court to extend that another 25 days in compliance with the rules of criminal procedure. So the Supreme Court would have to do that. As far as the court tomorrow, there's a hearing at 1:30, and the court has the option of setting, and what we're asking him to do is to set an evidentiary hearing because as the Arizona Supreme Court pointed out, there is a factual dispute. The current appointee to be the director of Department of Corrections has said we cannot carry out the execution, but the person who was in charge of executions, who left the office in January, paints a very different picture in his affidavit. So there is a factual dispute, and it will be up to the court to settle that factual dispute.
But would the court then schedule arguments?
It's up to the court how.
Well, there's a request for an injunction.
There's a request for, yes, an injunction, declaratory relief. The court could set an evidentiary hearing, probably in very short order, to resolve those factual disputes.
And the execution warrant, that has to be decided tomorrow because it expires tomorrow.
The court has already accepted the brief, so I would expect a ruling very soon. We actually submitted our reply last night.
Moving on to other subjects.
Okay.
How about you record it and you get the warrant in May 1st? We know the department is not, getting on it 35 days. So that's still going to give you enough time to another extension of the warrant. I mean, knowing that, I know what you said about, start at no, the current director says can't do it. So I mean, how do you see that moving forward and May 1st give you enough time?
That's going to be an issue for the judge to resolve in Superior Court as to whether they have the capability of doing it, and secondly, whether it can be done in that time frame. And we'll see where it goes from there.
On another subject.
Okay.
Is MCAO planning to follow Chris May's lead and now the governor's lead and ban TikTok on devices, work-related devices your employees have?
You know, I haven't decided on that yet, but it is certainly something that I saw and I'm going to take a look at.
Concerned by having TikTok on those devices?
I am not a techie, so I'm going to defer to the people in my office who are very adept at handling those matters, and I will follow their advice.
Ever seen a TikTok video?
Of course I have. I'm not that socially isolated, Graham. Have you?
A couple.
Okay.
The kids show me. Another job. How many abortion cases has the county attorney's office reviewed?
We have not received any submittals on abortion-related cases.
Have any of the recent Phoenix police officer-involved shootings come under review by your office?
For 2023, I'll just go back to January 1st of this year. One of those cases has been submitted. Sometimes it takes a little bit longer. Obviously, we're waiting for a variety of testing to be done, including toxicology screens, perhaps ballistics. So they aren't submitted immediately.
About your earlier presentation, you told us about the focus on the Bureau. Why did you say that there's a large backlog of many things that are backlogged? Why did you choose
that? The reason I set forth a separate stat for the aggravated DUI cases was because they were in a unique position. So there were unreviewed cases, that's the general backlog. The 800 cases I referred to were cases that had been reviewed and the paperwork for charging filled out, but they had not been fed into the court system. This happened over the COVID months, and so that was a priority for us to get those fed into the court system. But again, you can't just overload a court system or overload our office with charges. And so we did it in stages, but it has been done, and we're down to 0. Yes. One of the categories that we're prioritizing under the remaining 6,000 is a category that you've heard me talk about in the past, which is the misconduct involving weapons charges. That involves people who have felony convictions who are in possession of a firearm. We are seeing a strong correlation between having those charges in the past and subsequent violent behavior. So that is a top priority for me. I can't give you an exact number. We could look that up for you. I know that we have gotten that number significantly down.
Do you have a sense of what's going on with these cases? Gunplay, groups of people. Anecdotally, it feels like it's on the rise. Do you have a sense of whether it is?
You know, it does seem like it is on the rise, and I mean, we're seeing, if you just look at the cases you just asked me about, the officer-involved shooting cases, so many of those people were armed with a weapon, and many of those were people who were not supposed to be in possession of a weapon because they had a felony conviction. So I think that's a part of it, and that's why we're looking very hard at those cases and going to make sure that we're going to hold them accountable.
You see more gang behavior?
It does come and go. I wouldn't say necessarily more gang behavior.
Last 2 questions here. How is the current backlog of DNA testing affecting homicide investigations, including cold cases?
Well, obviously we deal with different labs. Phoenix has its own crime lab, Scottsdale, Mesa, and then of course there's the DPS crime lab. I know that they are working toward those. We did, when we got the Sex Assault Kit Initiative grant, try to ease that burden by going to privately held labs. to speed up that process. But I'm sure if you asked any of the labs, they would always say that it would be helpful to have more personnel. But I'll leave that question for them.
Using private labs costing more money?
Well, the grant funds paid for that. Actually, when we got the initial grant, they had already gone through a procurement process that we followed, and that involved a contract price.
And regarding the state lab in particular, have you moved much work away from them? Are they getting the same level of work from your office?
Understand that we don't submit cases to the lab. The police submit cases to the lab, so you would have to ask the police agencies that. We get cases once they've been tested by the lab.
Are you noticing any slowdown in those returns?
I haven't noticed any, but if you want us to look into that, I'd be happy to do that.
Just one more from your all cases should be charged within 90 days.
All cases should be reviewed within 90 days.
Reviewed and submitted.
Submitted to us, and 90 days from the submittal date, they should be. My goal is to have them reviewed within 90 days of the submittal.
You said we're getting
there. We've shortened it for certain so that we have fewer cases. I can't give you an exact average. Obviously, it's going to depend largely on the type of case. You know, some cases are 2 or 3 page police reports. Some are thousands of pages. Those take longer. Yes, we are tracking. Is that it? All right. Have a good afternoon.